First of all, I'll place on records my sincere gratitude to Dr. Manvi and Team Aravind for inviting me. I think I am the only outsider uh, here. So, thank you for the excellent hospitality. So, I will be talking on medico-legal aspects of endophthalmitis. This endophthalmitis is a very tricky thing because once they get a thicical eye, every day morning they look at the mirror, they will see this thicical and they will curse you. Lifelong, he and his wife, everyone will curse you. So there is no wonder that they go for these medico-legal cases. And the real life scenario we have discussed, the first thing that the surgeon sees, there is a phase of denial. This can't happen to me. Naresh also told the same thing. And after 1 or 2 days of putting increased steroids, giving 2 doses of Vislon, then only it dawns in their head that this is really endo. And then there are three aspects in the management of endophthalmitis. Actual therapeutic intervention, all of us discussed in the morning. Communication, very important. And start reinforcing against a potential litigation. Because this is the case where there is maximum litigation, this and trauma, both. So there are some Supreme Court judgments which tells what is negligence. We are sued for negligence, not for the fate of the patient. We are sued for negligence. So what is negligence? And like this Kusum Sharma versus Batra Hospital, there are a lot of verdicts where they say that if the doctors has the they should be protected if they have done the standard of care and there is what any other doctor would have done. So that is a standard of care you have to do. And what is the definition? In Jacob Matthew versus State of Punjab case, they said that it is just lack of following the standard of care. So if you get an endophthalmitis, don't worry, just follow the standard of care. There is no negligence. And medical negligence, this Consumer Protection Act came. We were included in 1995. After that, it's a sad story for doctors in India. And patient can sue us in all these places, civil jurisdiction, where civil court they can sue, and Consumer Protection Forum, very easy. Why people don't go to the civil court? Because suppose they want to sue for 5 lakhs, they have to 10%, they have to keep as court fee in the this thing. So they have to spend 50,000 rupees as court fee. So that is why people don't go to civil court. If they go to civil court, invariably they will win the case because some element of empathy, sympathy will be there for the patient. Consumer Protection Court, it is very easy. In a white paper, you write and give it, they will take the case. That is right. Criminal jurisdiction, unlikely. I will talk about that later. Then there are plenty of places, Human Rights Commission, Ministry of Health, the Department, Execute, everywhere, Medical Council, they can complain against. I have faced many of these. That's why I am little. So what I will do is, I will do a literature search, like we do in PubMed. There is something called India Canon, where you can put High Court or Supreme Court or National Commission verdicts and endophthalmitis. You will get all the data and put that in ChatGPT. You will get the summary. Okay, that is what I did. So I will follow, show you some cases of judgment from Supreme Court or High Court or National Commission. And it is called judge-made law. Who makes the law in India? Legislature, right? Parliament. But there are things called judge-made law. It is called stare decisis, where the verdict of the highest other apex court is binding to all others. Like we see, we refer, okay, that article showed that, but that is the drug of choice. Like that, you can say that judgment said that is so, we can quote that. So like that, there are plenty of judgments which we can use for our defense when we reply a court summons. So first of all, Pearl 1, bad outcome of surgery is not surgeon's fault. Okay, it's a non-complication. Endophthalmitis is not a surgeon's fault. There is a judgment like State of Punjab versus Shivram. Somebody did a sterilization surgery, patient became pregnant. So in that case, court ruled out the negligence because it is a non-complication. So in endophthalmitis, 2 out of 10,000 can get an endophthalmitis. It's not due to the fault of the. So only thing there should not be any negligence. Pearl 2, CAM cases are not exempt from Consumer Protection Act. Okay, this is number 2. Because this is some of you may be knowing this case, Tankama versus the hospital in 2012. It was a CAM case, got an end off. And first of all, let me tell that the patient has to prove the negligence. You have to defend only. So patient has to prove the negligence. How will the patient prove the negligence? Take all the documents. If you have not recorded anything, that can be pointed. Then usually they take a expert opinion or expert panel. They will tell you whether there is negligence. In this case, the court has ruled in favor of the patient because one expert witness said that there is government doctor said that there is no need of cataract. There was no need of cataract surgery, etc., etc. And a small amount was given to the patient. So, in expert witness is important. So, when you do something, you document everything. And the message I want to give here is scam cases are not exempt from this thing. So, if there is a consumer patient, there's a relationship between the patient and the doctor as a consumer. If some of the patients are charged and some of the patients are not charged, so all of us are liable, even if it is scam case. Then importance of OT sterilization, patient registers already sir has told in very good detail. One patient sued poor quality lens was the cause for my endophthalmitis. So the doctor submitted all the records, like all the surgery done on the same day, all the sterilization records, everything, same IOL, how many patients put, all of them are fine. And court said there is no negligence, there is no poor quality lens. So that is the importance of keeping the records properly. Value of time, very important. This was a case that we treated way back in 2001. Patient had surgery in Calicut and referred to us. We did vitrectomy and then scleral melt, etc., etc. They went to Shankar Nethralaya also, and then it was treated, became thiazigal. Ultimately, the weak point, everything was done properly. The weak point was there was a delay of referral to the vitreoretinal surgeon for 3 days. First, it was seen by us. So there was a delay from cataract surgeon. For that, it was amounting to negligence. If they don't have the facility of vitreoretinal surgeon, it should be referred immediately. So that is the value of time. Do the standard of care and fear nothing. Again, I am telling, standard of care is called Bolam test. What is Bolam test? It was way back in 1957, Bolam versus Friar Barnett Hospital Management Committee. There was a case. Somebody did a surgery in the vertebra or something and got a paralysis. It was a non-complication. So they asked 5 other doctors, what will you do in this case? You do surgery, there's a complication. So standard of care is called Bolam test. So the court will say whether you have done the standard of care. So they will test, Bolam test will be applied. And if it's standard of care, no problem. So what is the standard of care in endophthalmitis? AC or vitreous tap, intravitreal injection, vitrectomy, topical, systemic, intravitreal antibiotics, everything. As per any guidelines, AOS guidelines are there, or any textbook you have got. So based on that, you do the standard of care without losing time. So that is it. So there are some problems then in our current scenario. Like some surgeons, after the surgery, they will call the patient after 1 week. And like some freelancing surgeons are there. They will do surgery and then next week when they come, they will see. So these sort of things are not standard of care. Suppose it goes to an expert panel will tell that I see next day. This was not seen on the next day. So definitely these sort of things, like antibiotics were not given post-operatively or pre-operatively. These are all things that are not standard. So and these are problems of commercialization. And this can result in some problem, especially if you do. There are plenty of cases where the standard of care was observed, like this Ina Jain versus Paro Devi. All India Institute of Medical Science expert opinion said that it was a non-complication and they have done everything. So there is no negligence. So it was dismissed. Another one. And here also, they said that there was no evidence of negligence or delay in referring the patient to a specialist. Dismissed. Another case, Nine Deep Hospital. Initially the patient improved, then the standard of care was given and the patient lost the vision, but the court said that it is in accordance with the guidelines of AOS. So dismissed. And another one, Darshan Lal Arora versus Vivek Pal. It was the endophthalmitis court decided that it was, as per the expert opinion, it was just a complication of IOL surgery rather than negligence. Dismissed. So all these things are dismissed just because the doctor stepped to the standard of care. Document well with necessary investigation. Like this case, Triloginath, the actual vision was not recorded at all, and findings are not recorded. The doctor said in the court that patient is alcoholic, and then he fell down and had an injury. That's why. But when they checked the file, there was nothing mentioned about alcoholism. Not even the vision was recorded. So the compensation was given to the patient. That is important as documentation. Then this is another case, one doctor, patient and doctor surgeon. Yes, there were two problems in that. One, V-scan was not done after the endophthalmitis. And two, in the initial visit itself, the follow-up schedule was not given in writing. They told you come after 1 week. It was not written. So the doctor said, the patient said, I was not informed that I should come. So these 2 points cost the patient some amount. So that is against the doctor. Another one, out-of-court settlement. Many of people do out-of-court settlement. If you are doing out-of-court settlement, do it properly with the good documentation. Otherwise, you will be in trouble. That is another thing. And I am telling, it is the complainant's or patient's responsibility to prove negligence, and not your responsibility to prove that you are not negligent. So there are only few conditions where you have to prove, like res ipsa loquitur, which does not apply to us, like a mop inside the abdomen or something. You have to prove that you are not negligent. Patient doesn't have to open his mouth. So this is a case where the patient has to prove that there is negligence. So don't worry about that. Like Shobha Kini versus Agarwal was an eye hospital. Here also, the patient did not bring an expert witness panel. So it was dismissed. So it is the patient's responsibility. Another one. I mean, most of the cases are like this. I am not going into each and every case. Then important thing is do proper preoperative workup. Diabetes management is very critical. This case, the doctor said it is not my duty, it is the physician's duty. And he has not mentioned any diabetic level or patient was diabetic or anything. So the commission found that petitioner had the knowledge of diabetes but did not take steps to control before the surgery. What is the normal value and all is debatable. But if you think that the diabetes is there, I mean, it is needed control, you better send the patient to control it and then only do it. So exorbitant compensations, that is another thing that happening now. In a district level court, you know what is the amount they can ask for, patient can ask for? 50 lakhs. In a district consumer protection forum, they can ask for 50 lakhs. In National Consumer Protection Forum, how much they can ask? Ask 12 crores. Okay. So 50 lakhs to 12 crores. This is what usually every notice will have. So exorbitant compensations are not encouraged by, like this case had an ICL and then end of. It was in Center for Sight. He asked for everything, various grounds, including expenses, loss of earnings, future of medical expenses, damages for pain, suffering, and loss of marriage prospects. He wanted 6 crores. So the court dismissed the case, saying that this is exaggerated or unrealistic claims without considering the merit. Court asked them to go to the civil court and file a case for 6 crores. He has to give 60 lakhs, right? So consent is the most important thing. Without consent, if you do anything, you are out. So most of the cases, like this article in from Korea, it is most of the cases are due to improper consent. And Samira Kohli case in 2008 has defined what is a consent. It should be signed by the doctor, witnesses, patient, and in their own language. So what should be mentioned in the consent? You have AOS consent, which has a lot of things. You can modify it in your language, and uncommon dangerous complications like endophthalmitis and common mild complications like PCO, everything should be mentioned in the consent. And I did a study in Kerala, around 180 doctors responded. Only 75% of doctors are signing the consent. All of you sign the consent, you do? That is great. So only 75% of doctors even don't sign the consent. So this is the thing. And blanket consent has no value. And CAM also, you need consent. Anesthesia consent is separate. If you do a combined surgery, you need a consent for anterior segment and posterior segment. If the combined surgery is by 2 surgeons, 2 consents are needed. So these are all things that you should know. AOS consent is good. We make them write in Malayalam or their language. and sign. If it is a printed this thing, at the end of the paper, you write that in Malayalam or whatever language, I read and understood. At least that much is needed. So cluster endophthalmitis, I am not going to detail because it is a big topic and already RDR sir has dealt with it. And Justice Markandeya Kadju has clearly said that doctors should not be harassed. And it is not the court that has the expertise to detect whether there is a consent, when there is a negligence. And it should be referred to a proper body to find whether there was negligence, and then only court take action. So finally, how is the compensation calculated? It is called restitutio in integram. It means that what the patient could have earned in his life and what he lost because of the loss of eye. That is why it is called. It is the method of. It is called like that. So suppose a young child loses vision, and they will calculate his parents are doctors, so he will also become a doctor, and in 70 years of life he will earn this much, and they will give a huge compensation. But luckily, all of our cataract patients are 60s, 70s and retired. So probably all of them will ask for 5 lakhs, 7 lakh, 8 lakhs. They will get maximum on that much only. That is the silver lining. So there are so many cases nowadays coming. And suppose a patient from Jharkhand comes to Pondicherry, Aravind, and gets a surgery and goes there, he can give the consumer case there. So we have to go there and then at least send the advocate there. So that is a new thing that has happened in 2019. Jurisdiction does not apply. And there is something called a law of limitation, one word. You have to keep the files at least 5 years. It is said that 3 years for OP, 5 years for OT, but at least 5 years. Nowadays, EMR, it doesn't matter because it will be there with the server, stored in the server. So that is the thing. Except in pediatric cases, where the file should be kept till the child is 18 years. So at least 18, 20 years you have to keep the case in pediatric case. So silver lining is 98% of cases end up in favor of ophthalmologists. That is a good thing in endophthalmitis in the apex court, even though it may go against the doctors in the lower court due to poor contesting, and 98% goes in favor of. Thank you.